often falls short for marginalized people and to explore ways to make it more effective. And through this approach, she aims to illuminate the underlying assumptions of equality law and promote dialogues between normative political and social theories and legal practices. So with that, I turn over to you.
Thank you for everyone, and also thank the organizer for having me here. I would like to discuss two conceptual concepts of forced labor, and I am to present these two different ideas of free labor and to demonstrate that these concepts have historical backgrounds and also most importantly, practical implications here. So to begin with, I would like to introduce the two key concepts through a cold case in Taiwan involving forced labor and human trafficking. So please bear with me as this discussion of the case will take about half of my time. So Zhang Deming, the defendant, was the head of one of Taiwan's largest brokerage companies. In 2011, he was prosecuted for violating the Human Trafficking Prevention Act 2009. He was accused of subjecting Filipino workers to exploitative work through debt bondage. And it's also worth noticing that Zhang was very well connected politically. And one of his attorneys in this case was Vivian Sansan Huang, a former Taipei city councillor, a deputy mayor of Taipei, and currently serving as a legislator in Taiwan. So Zhang was alleged to have created a cross-border migration pipeline, profiting significantly from Filipino migrant workers. He operated a broker company and a financial company in the Philippines, as well as a brokerage firm in Taiwan. The Filipino brokerage companies were confirmed to have charged illegally high fee, up to 5 times the legal cap set by the Philippines. Since most workers could not afford these high fees, so Zhang's financial company then lent money at a high interest rate at 40% per year. So that's also 5 times of the legal limit. So workers were then required to sign promissory notes as security for their debts. If a worker failed to repay the debt on time, that's monthly on regular basis, the creditor could obtain a court order through a rapid procedure that only reviewed the formality of the papers. And as a result, 1/3 of the indebted workers' monthly wages would be garnished to repay the debt. And the public order and our courts effectively become Zhang's debt collection agency. And Zhang's company also submit false affidavit letters to apply for Filipino workers' visas and work permits. The affidavit is a document required by the Taiwanese government in which the broker and the worker declared all collected fees, loan amounts, interest rates, salaries, and future deductions. And this document must be notarized by officials in the worker's country of origin. And the notarized affidavit is a key requirement for obtaining visas, work permits, and temporary residency in Taiwan. However, as you might imagine, if the affidavit reflected the illegally high fee, officials would refuse to notarize it. As a result, affidavit seldom reflected the true extent to which the overcharging is practiced. So in addition to these financial abuses, workers also complained about false advertisement regarding future incomes and their working hours, and poor working and living conditions in Taiwan, and possible confiscation and partial wage withholding. So if you are familiar with all those indexes of forced labor and human trafficking, you would likely notice several signs of possible offenses in this case. However, the judge, Ya-Wen, ruled the defendant not guilty. And this judgment was later upheld by the Court of Appeal. As a result, the prosecutor stopped pursuing similar cases as the legality of this business model has been confirmed by the judiciary in Taiwan. So setting aside the outcome of this case, I want to draw your attention to three noteworthy points in the reasoning of the judgments. And first, the most prominent reason why John was not held liable was the issue of the workers' consent. The workers has entered into the brokerage contracts, the employment agreements, and the debts without obvious signs of violence and deception. They also signed the affidavits, promissory notes, and also gave their written consent for the withholding of their passports and wages. So the judge also noted that there were different companies in the market, and if the workers found John's services and fees unsatisfactory or unacceptable, they could have chosen another company. So no one forced them to work with the defendant. And secondly, regarding the overcharging, while it is true that the overcharging is illegal, the judge did not necessarily view this overcharging as debt bondage. In the judge's opinion, the overcharging was reasonable because the legal cap was widely ignored, and John's company was charging at the prevailing market rate. So interestingly, you see here, the judge acknowledged that the workers didn't really have genuine alternatives in the market, regardless of which company those workers choose to work with, they are going to end up with paying the same rate. However, this lack of choice ironically lessened the defendant's liability. And third, perhaps also the most disturbing, the judge argued that it was unfair to hold John responsible for the workers' heavy financial burden. After all, can we really blame businesses for seeking the highest possible profit? The judge also pointed finger at the Taiwanese government, stating that its minimum wage law, which is applicable to migrant workers, increased the human cost for employers. As a result, employers were reluctant to pay for the recruitment, so leaving the brokerage industry to collect these fees from the workers. So lastly, the judge also blamed the Filipino government for approving the forced dumping. So from this case, we can observe two distinct conceptions of free labor at play. One is coercion-centered view, while the other an exploitation-centered view. The judge essentially represents the classical, liberal, narrow understanding of free labor. This view considers free labor to involve workers who are unable to sell their labor in the free market due to physical, mental, or legal duress. But it does not regard economic necessity as coercive at all. So in this perspective, free labor is often equated with freedom of contract. And the labor market is viewed as a free zone. And free labor is seen as a deviation. And therefore, forced labor is considered an offense committed by malicious individuals only. And the state's role in protecting freedom is to punish those who use direct coercion, such as violence or threat. So on the other hand, the prosecutor's legislation under the HTPA aimed at reducing the economic burdens of cross-border migration represent an exploitation-centered view of free labor. From the exploitation-centered view, both non-economic coercion, such as threats and violence, and economic necessity, such as poverty and debt, can lead to unfree labor. So the state's task in protecting freedom is to ensure that fair options are available for all, so that people can make meaningful choices. Otherwise, as we can see in John's case, as long as migrant workers have no reasonable alternatives in the market, they will always be driven into debt traps, or worse, because their exploitation at the debts can appear just voluntarily. Of course, conceptual division is not new. The history of the creation of ILO Convention number 29, the Forced Labor Convention, reveals a similar conceptual structure. C-29 of 1930 is the first international instrument aimed at eliminating forced labor. It provides the legal definition for forced labor, which you can see on the screen. This definition forms the basis of modern anti-forced labor law globally. And as you can see, it follows a rather narrow coercion-centered idea. However, it is important to note that C-29 itself is a product of colonialism. During this drafting, European colonial powers explicitly defended forced labor, arguing that it was necessary to compel indigenous peoples in the colonized territories to work as it brought about civilization, development, and public order. And therefore, it should come as no surprise that the convention provides a narrow definition of forced labor and tolerates broad exceptions. On the other hand, during the preparation of the convention, it was already recognized and condemned that colonial powers could indirectly drive indigenous people into factory work or hired work through background institutional mechanisms, such as collecting very heavy head taxes or displacing people from the land that relied on for self-substances. And this is the idea of indirect compulsion. However, indirect compulsion was intentionally not incorporated into the definition of forced labor, despite having similar effect to direct threats and violence. And today we can observe the old conceptual struggle reflected in the trajectory of the ILO's expert committee's comments. Its perspective is shifting from a mainly coercion-centered view of forced labor to a more exploitation-centered view influenced by the anti-human trafficking law. And although it cannot change the official coercion-centered definition under the Article 2 of ILO Convention number 29, it can suggest a broader scope of the state's responsibilities in eliminating forced labor. This shift involves moving from merely prioritizing abolition to enhancing workers' capabilities. So to protect abolition, the state is now expected to punish forced labor with sufficiently severe penalties and also avoid imposing illegitimate limitations on workers' job mobility. To enhance capabilities, particularly in the context of migrant workers, the state should ensure fair recruitment practices to prevent workers from falling into debt and guarantee that all workers are protected under labor law. And how well does Taiwan perform in eliminating forced labor among temporary migrant workers? In short, Taiwan has failed in both the coercion-centered and exploit-centered view. Taiwan only introduced a universally applicable criminal penalty against the forced labor as recently as this year, largely due to pressure from the U.S. trade-free talks with Taiwan. And it remains to be seen whether the law will be taken seriously. Taiwan also consistently limits temporary migrant workers' job mobility. Despite criticism, so during COVID-19 pandemic, the government further restricted temporary migrant workers' mobility by closing of their channels to switch jobs categories. So as a result, caregivers have found it nearly impossible to secure better paying factory jobs. And in the context of Taiwan, this kind of limitation has been considered as an extension of the state's prerogative of controlling the border. So these limitations has seldom been challenged. So furthermore, Taiwan's management of the broker industry is chaotic. There are virtually no effective policy tools to control the cross-border overcharging by intermediaries, leading to rampant illegal fees and exploitation. Additionally, Taiwan's Ministry of Labor excludes domestic caregivers from the protections of general labor law, and there is no political will or momentum to create a special labor law for caregivers, so leaving them in legal limbo. And so more importantly, Taiwan justifies its value with rhetoric about consent and freedom of contract, arguing that workers consented during the recruitment process and they are protected by their employment contracts. And therefore, a special labor law for migrant workers is not really needed. So to conclude, forced labor is not just a random offense committed by greedy individuals. It is an institution on its own. It is a mode of economic production, often imposed on outsiders, such as indigenous peoples during the colonial era and migrant workers today. So from this perspective, this perpetuation of forced labor relies on reproducing unequal legal status among different groups of people. So the ongoing fight to eliminate forced labor is deeply connected with the realization of equality. Okay, I think I'll just stop here.
For that, and it's impressive how both speakers stayed within the time limits, and I appreciate that. So now we open the floor for discussion, and we deliberately allotted more time for discussion for half an hour, right? So we have until 11:10 according to the schedule, but I think we can go a little bit over, right? Okay.
Yes. Yeah.
Okay, good.
Yes, this one.
All right, very good. Yes, we can. Should I give the? No, that happened. Yeah.
Thank you very much for the presenters, and I also appreciate, the link with the ILO for both papers. But I have a question to Yang about the model that you have been presenting, and I would like to ask about the exploitation census view. So maybe you could explore it a little bit more, because you talked about the capabilities.